Okay, more social media lawyer posts, and you're welcome. But here's what today is. Today is talking a little bit about buy-sell agreements, right? Like I mentioned this in one of my other posts, that I would come out with something that talked a little bit about buy-sell agreements. What do you do if you've gone into business with a friend or a partner or a family member, and now somebody wants out, or something's happened, somebody's died? Like, what do you do? So earlier we talked a little bit about setting up a limited liability company, and you would need an operating agreement. And you know what? Another teaser. I'll do a post at a different time about what should go into that operating agreement if you have more than one owner for your company. So let's assume you got more than one owner. There's a 1, 2, 3, 4, 5 of you, whatever the number is. There's more than one person that owns this company or this LLC, and you need to be able to deal with situations where somebody gets divorced, somebody dies, somebody wants out, somebody's not pulling their weight, whatever the case may be. So here's how you do that. You do that with specific buy, sell, as in buying or selling, their membership interest provisions in your operating agreement or in a separate buy-sell agreement. Doesn't matter one way or the other. You just got to have the language in there. So the idea being, you've got a set out number of circumstances. I kind of referenced a few of those. If somebody dies, if somebody is going through a divorce and it looks like their soon-to-be ex-spouse is going to become one of your partners, or maybe you've got somebody who's stealing from the company, you've got somebody who's just not pulling their weight. I mean, everybody promised to do X, Y, or Z, and then the third guy in the group just stops showing up and just wants a check. So what do you do there? And then finally, just what if somebody wants out? They say, look, I've had enough. I want to leave the company and go do my own thing. So I call those triggering events. And you kind of want to set out a list of triggering events. You may have some more depending upon your situation. And say, look, if one of these things happens, we want to be able to move forward in a way that makes sense without us all suing each other. So you'll have your triggering events, and then you'll have your next steps, right? So the easiest one is, what do you do if somebody dies? Well, if somebody dies, I mean, frankly, you signed up to work with them, not with their kids or their spouse or their beneficiaries, right? So this provides a mechanism that says, look, if so-and-so, one of the partners dies, their ownership is going to be sold back to the company or sold back to the other owners, okay? And so you would set out a mechanism in your buy-sell agreement that says, all right, if partner 3 dies, then partner 3's ownership interest is valued. So usually like some sort of appraisal, or even you can even agree ahead of time on what the value would be. And then once you have that number, the company then will buy that interest back, or that ownership back, from the partner who passed away, from their estate. Okay, and then you can even build in terms, maybe it's a lump sum. Maybe the partners all have life insurance on each other, so that, if a partner dies, that life insurance funds the buyout. Or you can even work in, I call it seller finance, but you could work in a scenario where if the partner who passed away, if their interest is worth $1 million, then the company would then, enter into almost a payment plan with their estate. So maybe their surviving spouse or their kids almost get like an annuity over the next 5 or 10 years, where the company can pay so much per month or so much per year. So a couple of different ways to do that. So long as everybody's on board, it's easy, right? So what happens if not everybody's on board? And this is usually where things tend to go south. A partner who's leaving wants to exit the company. They often will have a different opinion on the value of their ownership versus the partners who are buying their interest back, or the company that's buying their interest back. And that's where it can get a little sketchy. So I like to put language in these buy-sell agreements that says, listen, the leaving partner, if the parties can't agree on a price, then the leaving partner can go ahead and hire their own appraiser. The company will hire its appraiser. And if those two appraisers are more than, 10% apart, then the parties will agree on a third appraiser, and then they just average them out. So that's one way around it. Also, if you have a leaving partner, a lot of times you may want to think about whether the company is going to want a non-compete restriction. on that leaving partner so they can't, set up shop across the street and start a competitor. You would build that into the buy-sell agreement so everybody knows that ahead of time. But really the key is, when you go into business with other people, when you've got partners, I would love to say that every company lasts forever, every marriage lasts forever, but they don't. And so you have to plan for those scenarios where what happens when you break up? What happens when something happens, somebody dies or somebody becomes disabled, they can't work anymore, or like I said, maybe a divorce where all of a sudden one of your partner's ownership interest is going to get distributed to a spouse as part of a settlement in a divorce. All those scenarios take that certainty of who your partners are going to be out of your hands. So to the extent you can plan ahead and put the right information in a buy-sell agreement, you can protect against that. And hopefully only work with the partners that you want to work with and not with maybe their family members or somebody else you didn't sign up for. So hopefully that's helpful. And if you have questions on buy-sell agreements, you can always find me somewhere. So, all right, good luck.